Oh, it would clearly be culpable. I mean, any of the things that get enmeshed in this would be culpable. The question is whether they deserve 3 years in the penitentiary. Bear in mind, please, that during the course of the analysis of this section, that although it is predicated on the question of danger, danger is not part of the elements of the offence of this particular matter. Parliament could have said in a dangerous way, or for dangerous reasons, or putting people at risk, or things of that nature, but it did not. There's no element of danger in this. There's no element of, for example, that the possession is other than transitory or other than quick. A person can literally handle a firearm for 45 seconds and be guilty of this particular offence. The Smickle facts, for example, although Justice Doherty found no favor with this argument, I'll try it out on this court. The question about somebody walking into a room, for example, and I'm changing the facts in Smickle a touch, but bear with me. Somebody walking into a particular room which belongs to a cousin or what have you who's a bad man, which is very much the facts in Smickle. He walks over there and says, oh, look, here's this firearm down there, and there are a couple of bullets, but it's unloaded. In Smickle, it was loaded. That's the part that I'm changing. You walk in there and you say, hey, how cool is this? And you pick it up and you take a little selfie of yourself, and then you're interrupted 30 seconds later, right? That's the nature and the extent of the criminal culpability which leads to that particular finding. In my submission, I mean, I'll address this head on. That particular question, that particular offender would be grossly disproportionate to sentence him to 3 years in the penitentiary. If that gun was unloaded, the fact that there are bullets that are rattling around on the table in front of him means that the sanction which should be applied to the person who left those things around is significant. But to the poor young dupe who picks it up and poses for it for a second before being interrupted, in my submission, he has not actually put anybody at risk. Bullets are not like amoeba that float into the gun and all of a sudden can discharge automatically. The question here is if he postures with this particular gun for a moment, which of us as young persons, perhaps not you guys, which of us as young persons has not done something foolish briefly in our lives, right? Did we all deserve to go to the penitentiary for 3 years for? In my submission, it's grossly disproportionate even on that particular basis. So, I mean, and there's an example about a sort of a young urban fellow actually holding it, and it's not a sort of a rural cottage owner, so didn't find favor elsewhere. But in my submission, that would be a reasonable hypothetical that you could find, and is closer to many of the reported cases in my submission. Although I have to pause for a moment and say that you should be very, very careful about the use of the charts. I say this very respectfully to my friends from the Attorney General for Canada, about using charts about reported decisions as some sort of empirical survey from which to conclude anything. The nature and the effect, these were not statistics which were put forward as part of any prior litigation. There's been no analysis of them. How it is that they came forward is still somewhat opaque. The question about whether or not they are accurate, whether or not they properly capture a broad range of what actually exists in Canada has not been tested, and my submission has not been tested at all, and you should be very cautious before you should use them at all. Now,
you've been arguing that cases like Smithell and so on just show that this law can have grossly disproportionate effects. Why do you need the reasonable hypothetical?
The question about the reasonable hypothetical, and it's a useful point to get to right now. The question about the reasonable hypothetical is that to a certain extent, and this is an answer to what you said earlier, Chief Justice, is that to a certain extent, when one comes to constitutional litigation, where one's defense against the state is predicated on the fact of the unconstitutionality of a given law, the character of that litigation changes. It no longer fundamentally is the fact about only applying to you in my submission. To a very large measure, it applies to the question about the proper constitutionality of that particular section. And that, to a certain extent, is the question about Big M. Now, we can argue it based on the fact that that's an established principle, but you can also argue it based on a series of other principles. You can argue it based on access to justice, for example. It's not everybody who's going to be able to wield the sword of constitutional litigation. Many cannot. I included that case about Morrison, about that poor hairdresser woman who didn't want to bear the weight of constitutional litigation, so resigned herself to a 3-year sentence, where Justice Cole in the provincial court seemed very unhappy about the idea of wielding it. One of the reasons why it is that we do reasonable hypotheticals in my submission has to relate to a question of access to justice. But the other thing is, and I appreciate the question that by and large the common law tradition, generally in fact, the common law tradition is to decide things based on established cases. But to a certain extent, we have to move outside of that in certain cases for the reasons that we've put forward.
Oh, my question is a little narrower.